Call Miss Foster. Call Miss Foster.
Calling case 230-588-8201, People of the State of Michigan versus Kamisha Danielle Foster. Defendant charged with count 1, assault of a prison employee. Count 2, criminal sexual conduct, 4th degree, force or coercion. SORA notice. Today is the date and time for a bond redetermination hearing.
Judge, can I have a 10-second breakout room with Ms. Foster? I apologize, brother counsel.
What's the current bond for Ms. Foster?
50,000 cash.
50,000, 10% monetization.
I'm sorry.
Yeah, okay. All right. Okay.
Thank you.
Argument.
Judge, my client's 28 years of age, Judge. You know, she's in the Wayne County Jail, Judge. She's been in there. It's my understanding since, you know, for a while, Judge. This alleged situation, Judge, was my client allegedly touching a guard on the behind in passing. Now, you know, obviously it's allegation, Judge, but even if you would say the allegation is true, you know, it may be highly inappropriate, Your Honor, maybe highly inappropriate and offensive. I think that, you know, 50,000, and I have 50,000 cash.
I have 10%.
Yeah, 10%. Sorry. And I think just 50,000, 10% is excessive. And I'm not trying to downplay anytime anybody is touched without their permission. And, you know, it's unacceptable. But I just think that 50,000, we're not talking about somebody striking somebody, slapping them, you know, stabbing them, you know, I've seen 50,000, 10% bonds for FAs. You know, we're talking about, you know, and obviously the CSC 4, it's a high misdemeanor. It's inappropriate touching. I'm asking for a reduction, Judge, for personal bond. Obviously no contact with the guard. I mean, you know, no matter what the situation is, whether it was they, you know, we're talking to each other or whatever, I don't know, but no contact. And again, Judge, I've talked to Ms. Foster, and we understand that it's highly inappropriate. It's just highly inappropriate. So I'm asking the court to consider that, Judge.
How long is Ms. Foster due to be in the Wayne County Jail?
Ms. Foster, when do you get out?
2 days. Sunday.
You said Sunday?
17th, yeah, Sunday.
17th, the 17th, Your Honor. She had a violation of probation.
Mr. Prosecutor.
Thank you, Judge. I guess I would just like to start in the wise words of Yoda. Many of the truths that we claim to depend on our points of view. In the prosecution's point of view, Judge, we're going to be asking for an increase. And if you would allow me, Judge, just a couple of moments just to let you know why. So we have this incident. We have the deputy that's just performing her job. We have the defendant who grabs her, who creates a scene in Wayne County Jail. All of the inmates have to go on lockdown. We have a defendant who subsequently ended up saying, before she gets put in her cell, that it was worth it. We also have, Judge, in the last 3 years, we have this defendant who's pled guilty in October of 2020 to an A and B. We have this defendant who's pled guilty to an attempted R&O in May of 2022. We have a defendant out of the 19th district who pled to attempted refusal to obey officers. We have a defendant who has a bench warrant out for her arrest out of Wayne City Airport, the 34th district, for failing to appear on a trespass charge.
Sit up, Ms. Foster. Ms. Foster, sit up. Sit up. This is not a time to be lounging and you keep stretching. Just sit still. Sit still. This is a court proceeding. Even though it's via Zoom, this is a court proceeding. This is not yoga practice. This is not time to get centered. Just sit still. Continue.
Thank you, Judge. And then we also have another officer in the city of Detroit who previously had to take a PPO out against this defendant in May of this year that this defendant has already violated, coming up to the jail, harassing that officer, Judge. So we have a bunch of things going on. With all due respect to defense counsel, this just isn't about this one particular incident. And Your Honor, I hope you do take into account all the prior offenses, assaultive offenses, the fact that a different officer had to take out a PPO. And now, given the opportunity, Judge, given the opportunity, she does what she does in jail, of all places, in jail, of all people, to a deputy. And then afterwards, she says it was all worth it. So, Your Honor, with all due respect, defense counsel and I see this completely diametrically opposite. I would ask for an increase in this, Judge.
Because we're talking about bond, and I appreciate brothers counsel's, his soliloquy about all the priors and the different situations, but we're talking about what she's being charged with here, and we're talking about bond. Bond is meant obviously to protect the community, and it's also meant to have someone come back to court. Now, there are some misdemeanor cases in the prior. She has an R&O, but I think that Judge, touching somebody on the behind is very serious, Judge. Even grabbing somebody on the butt, whether it's in fun, whether it's joking, whether it's flirt, whatever, it's inappropriate. It's just inappropriate. Does it rise to the level of a 50,000, 10% bond? No, Judge. We have FAs, we have GBHs that get that type of bond. I'm just asking for a more reasonable bond. And I'm not, I don't want the officer is an officer, but if it was a person that wasn't an officer, it's still wrong. I mean, I don't want it to say that because it was an officer, that makes it even worse. No, you don't do that, period, to anybody. So I just think and that the bond is excessive based on this particular charge, Judge. So that's why I'm asking the court to reduce this particular bond.
We haven't heard the arguments for counsel. Court finds $50,000 10% bond is an unaffordable bond. Court, and if the court is going to do an unaffordable bond, the court has to take into account flight risk as well as dangerousness to the community. Where this case is a little bit interesting is when I'm trying to assess dangerousness. If you're in line at a concession stand and you grab someone's butt, that is, that's assaultive conduct, it's inappropriate conduct.
It was mutual flirting in front of everybody.
Okay, ma'am, please don't cut me off or talk while I'm speaking. Okay, I appreciate it. Now, if a person is in jail and is grabbing the butt of an officer, it makes me question impulse control. It makes me question a whole lot of stuff. And I did just hear the defendant state that this was mutual flirting. Okay. I think everyone in this Zoom room has been engaged with mutual flirting before, but I've never had mutual flirting where I thought it was appropriate to grab someone's butt doing the mutual flirting. That's just not how that goes. That's not how the escalation of mutual flirting and in jail and in front of other people. It's just a lot. And I'm not going to get into victim blaming, or I'm not going to get into that the deputy wanted to be grabbed on the butt, because if the deputy wanted it, most likely there wouldn't have been the lockdown, and there wouldn't have been all of the chaos that ensued, the charges, bond hearings, arraignments. And so we just need to kind of, have a little better impulse control. If you want to flirt with the guard, I guess there's an appropriate way to, actually, there is no appropriate way to flirt with a guard, because there's a power dynamic between the guard and the prisoner. It's actually a crime for the guard to be engaged with a inmate. So there is no mutual flirt. This is a prohibited situation on its face per se. This is a situation that can't occur. But what really can't occur is an unwanted touching in a sexual manner of a prison guard. So with that being said, court is going to reduce the bond from 50,000, 10%. The bond will be reduced to 10,000, 10%. With a GPS tether, a no contact provision, and a 10 p.m. to 6 a.m. curfew. Thank you very much.
Thank you.